Good morning. Welcome to the second fraud breakfast briefing. Today we're talking about a case from cradle to grave. We want you to imagine you're a GC in a company, a small family construction company, UK based, with average annual turnover of 50 million. You employ around 250 people, 50 of whom are in Qatar. You operate in Qatar through an agent, which is the local convention, and sell specialist construction equipment to the state through state contracts. You've just fallen out with your agent in Qatar, and in the midst of the dispute, there's been non-specific allegations of fraud. And some of the allegations relate to corruption and that your employees in Qatar have bribed officials in Qatar to get your contracts. So that's the first thing. You've been asked to investigate. What do you do? So you start looking at the claims, and at the same time, a whistleblower comes forward and says that 4 of the company's senior employees in Qatar have been involved in a scheme to give cash incentives to Qatari officials in order to secure the contracts, and that they themselves have also been siphoning off funds to fund their lifestyle. And those funds have been put into offshore accounts. What we want to do is take you through the things that you need to think about as that GC and how you would approach the investigation. First up, we've got Ben Lowans. Discovering the fraud, the first 24 hours. Don't panic.
And that quickly. Yes, good morning. My name's Ben Lowans. I'm a partner here in the litigation department. I'm also a certified fraud examiner. And I'm just going to talk for 10 minutes. As you'll probably notice, we've got a tapas of speakers today. So it's all going to be short and I hope sharp presentations in respect to fraud. But for the next 10 minutes, I'm just going to talk really about what you should be thinking about. Although I've given it the first 24 hours, it will of course depend on the circumstances. You may need longer than that, and it may well be the circumstances of the fraud require you to make your decisions in a longer period than that. But I suppose the 24 hours is this: it's to stress that almost inevitably or invariably, in my experience, if you don't act quickly, ultimately you will pay for it in the long run, and pay for it in terms of costs, in terms of chances of success, in terms of achieving your objectives. So that early period when an investigation, when a fraud has come to light and you have to investigate it, that first period is absolutely crucial. And in particular this is the bit I really want to leave you with, setting your objectives. It's absolutely vital, once you've discovered a fraud, that you think carefully and set your objectives. Almost necessarily, when a fraud is discovered that's unknown about, there is an element of panic, and an element of muddled thinking, an element of that sort of shortness of breath, that pumping of the heart, and that's just me as your legal advisors when I come in. But that happens, and it's quite natural, because if frauds are discovered, people weren't expecting them, and there's a lot of uncertainty and decision making that needs to be done. So the important thing is to think carefully about your objectives, and it's the conversation I will always have first with clients when they come to me is just what do you actually want to achieve. Often they won't know, because they'll know that there's a fraud and they want to deal with it, but they won't necessarily have thought through. So you can talk through their objectives. And very often actually, although frauds are, each fraud is different, frauds have a lot of similarities, not least that there's always an element of dishonesty, but there's often the objectives actually they vary from case to case, but often they'll be similar. So you may well want to, if the fraud is ongoing, you're going to want to turn the tap off. You're going to want to make sure that your business isn't losing any money. You may well want an investigation because it needs to go to the board or to shareholders or to some other party who may have invested in the business. You may well want to an investigation and a report to be produced to look at the operational errors and what steps need to be made. You may well want to take civil action, perhaps urgent action using a freezing injunction or other type of urgent order. You may want to bring a claim to recover the money as well as or as part of that. You may want to notify the police. You may want to report or feel that you are required to self-report to a regulator. Now, all those things may be objectives, or none of them may be objectives, or one of them may be your objective. But it's very important within the early period that you think carefully about your objectives and define them. It's perfectly possible, of course, that your objectives will change, and it's quite right that you should be flexible enough to change your objectives. I dealt with a fraud recently for a corporate client. It was an employee fraud, and it came to me and we talked about the objectives. The objectives initially started as primarily being an investigation into what had happened, and also in the role that in particular that I was playing was to go for a freezing injunction and pursue the fraudsters. That we did, and we got to a certain stage a few weeks down the line where that was fine, but by that stage, largely because of decisions being made by the board and by those investing in the company, it was felt that we ought to report to the police. Now, initially, within the first 24 hours, actually, that wasn't an objective of the client, but the client was flexible and changed that objective. It didn't impinge in terms of anything that happened previously when we set the objectives, that it was contradictory to reporting to the police, but it was a change of objective, and that, of course, does happen and naturally happens. But if you don't get that clear thinking, get those objectives set straight away, you'll waste time, you'll waste resource, and you'll waste cost. And worse than that, you'll actually go back and spend time thinking why you wasted time, cost, and resource. So it's essential to set those objectives. Securing and preserving. This is primarily, but not solely, about documents. Necessarily, whatever objectives are set, you're going to need documents. If you go to the police, you're going to have to package up documents and show that there's been a fraud. If you're going to bring a civil claim, you're going to have to package up documents and evidence that fraud. Any sort of internal or investigation that is carried out, which is going to lead to a report, will need to be supported by documents. That's documents, hard copy documents, and also, crucially, in today's age, electronic documents. It's very easy for those documents to be lost. That could be done inadvertently, but it also, there's a great danger that it might be done wishfully by those who have committed the fraud, particularly if that fraudster is still involved in the business. It may also be actually that the fraudster has friends in the business, or people perhaps who weren't the fraudsters but were complicit in the fraud. So there's a real risk when there's been dishonest conduct and you're facing a loss, that actually that people interest will be, of course, to cover up that dishonest conduct. And a way to cover up that will be to take away the documents that evidence that. So it's very crucial that that sort of, I suppose what we would call a lockdown, happens quickly. And a key part of that is the documentation, both hard copies and electronic documents. As well as that, simple things, I suppose, that you need to think about and get advice on. If your fraudster is an employee, or there's people who perhaps complicit in the fraud, what are you going to do with them? You can't have them wandering around your business and having that access to your IT systems and such like, which may impinge your investigation. Michael will talk about this in greater detail, but if it's an employee fraud or a fraud that's been committed against you where employees are suspected of being complicit with that fraud, then you naturally need to think carefully and perhaps take external advice as to how you deal with them. Very simple things. I see a number of frauds that come to me from corporates where the individual has been part of, or dare I say it, even leading a finance department, and may well have a management position where they have authority. It goes without saying, but I do have to advise on this, and it has been missed before, that it's not a good idea if you think somebody's been taking money from you to allow them to still have access to your checkbooks and your accounts and be able to sign things off. As I say, you'd be surprised, but I do have to advise on that, and have had to in circumstances where I suppose in those opening 24 hours of fraud where something as simple as that had been missed. The last bullet point, this is very important for lawyers, but it is actually very important for you as the client, but is often something that's missed. The concept of privilege is a talk in itself, but essentially it's that protecting documents that you might have in your possession, including electronic documents, and making sure that those documents, if you end up in any proceedings, don't have to be sent to the other side. Now, there's ways to make sure that documents come within privilege that we can advise on. And it's very important that this is done at an early stage if you are likely to end up in proceedings, because documents that you can think are very confidential and include confidential views and opinions aren't necessarily privileged. And one of the bits of advice that I always end up giving when dealing with frauds at an early stage is how to ensure that as much documentation as possible is kept as privileged and therefore doesn't have to potentially be released at a later stage to the other side. Yes, assembling the teams, this is very important too. It does link in a little bit with what I've just said about privilege. When frauds happen in businesses, invariably people are very interested by it. It's a big thing, it's important to the business at the time, there's immediate steps that need to happen, so there's an energy and a momentum and an importance, and the investigation necessarily is going to suck up time. Now, whilst a whole vast array of people might be interested in the fraud, my advice is always to try and keep the team narrow in terms of those who are dealing with the fraud. The danger is the more people who know about it and know what's going on, the more likely that anything confidential is dissipated and gets out. And that could get out to the detriment of any proceedings, including any criminal investigation by the police, and it can also perhaps get out into the press that you might want to, or indeed to shareholders, and have some sort of reputational issues. So we always recommend that you keep a small team of people who keep the information and deal with the fraud internally. And we often advise that you actually use non-executive directors. They're great because they have that independence from the main board, and also can have a distance, I suppose, from the business, which can help in clear thinking. Also important in terms of your external advisors. I'm going to say something now which you can all groan at. Get your lawyers in early. No, we won't do panto. But I know it's very easy for me to say that, and it's like I'm in terms of why wouldn't I say that? Because it gets in and I can bill some fees. But the very important thing is that if you take those early steps, particularly say the privilege point that I've just made and the retention of documents, actually you will save time and you will save cost in the future, and you're far more likely to achieve the objectives. And you won't be surprised to hear, but accountant friends of mine say exactly the same. Just some other considerations. Really, this is just a checklist of things that to think about where if you do have a fraud and you find a fraud, and decisions need to be made, not necessarily early on, but it's important you think about it. Are you going to notify the police? If so, when is the best time to notify the police? Often it won't actually be the best time to notify the police straight away. Are you regulated? Well, you should know that answer to that question, but do you need to notify your regulator? What's your obligations to your regulator? What has happened, and do you have obligations to self-report? Do you have insurance? Do you cover fidelity insurance? If it's senior management, is there any D&O insurance that might cover? And if so, what are the conditions? So for example, some fidelity insurance will require you to notify from the police, so you may well want to be contacting your insurance brokers and making sure that you don't give them an excuse not to cover. And PR strategy, I always advise on this because it becomes so important. It can be the internal facing communications, what's said and when, how is it said. Very often in the early stages we'll actually be avoiding making any internal communication, but at some point in time there's likely to be some internal communication. And also the external clients always ask me about PR, about reputation. Are the press going to be interested in it? If I go for this objective, is the press going to find out about it? It may well be for a corporate that's listed. You have to think carefully about how it's dealt with at any AGM, any announcement to shareholders. So there's always a piece for that to consider. And it's important that it's considered early, because if it gets out through other means about the fraud or what might have happened, then it might well be that you're reactive in your PR. You're dealing with the press who are phoning up with you, phoning up and asking questions, where of course it's much better if you're the ones in control. So that is a sort of whistle-stop tour of the first 24 hours, leaving the message of don't panic, act quickly. Thank you.